All right, so welcome to the last week of the agreement of sale, us going over the entire agreement of sale. We left off at the bottom of page 12 the last time, and the reason I did that was it started paragraph number 26, talking about default, termination, and return of deposit, and I wanted to keep the conversation all together for this week about the deposit money and who deserves it and how you get it back. So 26, default, termination, and return of deposits. A, where buyer terminates this agreement pursuant to any right granted by this agreement, buyer will be entitled to a return of all deposit monies paid on account of purchase price pursuant to the terms of paragraph 26B, and this agreement will be void. Termination of this agreement may occur for other reasons, giving rise to claims by buyer and or seller for the deposit money. So what it's stating there in A is there are throughout the contract paragraphs or phrases, whatnot, stating that the buyer is entitled to all deposit monies. Okay, we've seen it, we talked about that. However, termination doesn't have to be just those items, it could be anything else. And then that may give rise to claims between the buyer and seller for the deposit money. So if you represent a buyer and you are terminating an agreement, you do it through what's called the termination form, right? Usually on top it's a termination, at the bottom there's a release where the deposit money goes. So in the top termination, it asks for the reason why, usually citing a paragraph or whatever reason it is that the buyer's terminating. Now, if you're terminating for a buyer and they want their deposit money back and they are entitled to it, you need to kind of reference where in the contract it says that, okay? So I'm going to scroll down real quick to the next page that I wrote out here. And if anybody can go through this contract and find other places where it clearly states buyer is allowed to terminate and then get their deposit money back, please let me know. But I went through this contract with literally a ruler line by line and highlighted every single place where it says that the buyer is entitled to their deposit money. So you can see right there, zoning, you know, right on page 3, it would be above the mortgage contingency. Remember, you have to put in, if it's not residential, whatever it is, the mortgage contingencies, evidence of loan approval, conditional or unconditional. If the seller backs out because they didn't receive it in time, or if they reject the mortgage contingency, the buyer is entitled to the deposit money. So there's all the list. And you probably should save this sheet, okay? And if you ever write a termination, it should reference one of these, because that's the paragraph that states the buyer is entitled to deposit monies. Okay? Any questions? Okay. 26B, regardless of the apparent entitlement to deposit monies, Pennsylvania law does not allow a broker holding deposit monies to determine who is entitled to the deposit monies when settlement does not occur. Broker can only release the deposit monies 4 ways. 1, if this agreement is terminated prior to settlement and there is no dispute over entitlement to the deposit monies. A written agreement called the release, signed by both parties, is evidence that there is no dispute regarding deposit monies. Okay, that's why Seth is always on you about filling out that thing properly and having it signed. Okay. 2, if after broker has received deposit monies, broker receives a written agreement that is signed by buyer and seller directing broker how to distribute some or all of the deposit monies. So number 2, the way I read it after reading it several times is it could be in the contract that states that the deposit is non-refundable, or if, let's say, it's non-refundable after 90 days, or it says something to that extent. Now, Jim Goldsmith just recently sent out a PAR article about that non-refundable deposit, which I think Brooks had sent out last week, and hopefully everybody read it. And Jim Goldsmith's opinion of the term non-refundable deposit is not good. He went on to say, well, what if you wrote a non-refundable deposit and then the seller backs out? Does the seller have to refund the deposit then? It's kind of implied, right? If the buyer doesn't buy the house, but it's not written anywhere. So the other thing he mentioned was, what if the house is in an HOA or a condo association, and after the buyer receives the condo's docs, it states that there's, let's say, a assessment, special assessment for roof that's 17 grand, and the buyer doesn't want to buy the condo now. You know, are they entitled to deposit of non-refundable deposit then? Okay, so just be careful when you do that, because there's terms and languages that have to be included, because non-refundable isn't just non-refundable. Okay. 3, according to the terms of a final court order. Number 4, according to the terms of a prior written agreement between buyer and seller that directs the broker how to distribute the deposit monies if there is a dispute between the parties that is not resolved. See paragraph 26C. So number 4 directs you to C. Okay. Any questions on those 4 items? Okay. Part C, 26C. This is the part where we can make changes to this contract to benefit one party or the other. Okay. Buyer and seller agree that if there is a dispute over the entitlement of deposit monies that is unresolved for blank days, 180 if not specified, after the settlement date stated in paragraph 4A or any written extension thereof, or following termination of the agreement, whichever is earlier, then the broker holding the deposit monies will, within 30 days of receipt of buyer's written request, distribute the deposit monies to buyer unless the broker is in receipt of verifiable written notice that the dispute is the subject of litigation or mediation. If the broker has received verifiable written notice of litigation or mediation prior to, I underline prior, the receipt of buyer's request for distribution, broker will continue to hold the deposit monies until receipt of a written distribution agreement between buyer and seller or a final court order. Buyer and sellers are advised to initiate litigation or mediation for any portion of the deposit monies prior to any distribution made by broker pursuant to this paragraph. Buyer and seller agree that the distribution of deposit monies based on the passage of time does not legally determine entitlement to deposit monies, and that the parties maintain their legal rights to pursue litigation even after distribution is made. Okay, so that's a mouthful there. But what it states is the blank days, okay? If you represent a buyer, you want that closer to 0 as possible, correct? And if you represent the seller, you want that as close to 180, if not even more, because prior to this edited contract, years ago, it was actually 365 days, okay? They reduced it to 6 months. So let's say you have an issue with a deal and everybody's fighting over the deposit money, and the blank space there says 60 days, okay? And day 61, nothing's been filed, okay? No mediation has been mentioned, no district justice, nothing. Then you, as the buyer agent, or the buyer can write a note to the broker holding the deposit, asking for the deposit money. Now, once the broker gets that, then the next 30 days after that, at some point, they have to return the deposit. Okay, unless they know that there's a litigation already filed at that time. Okay, now I underline prior because I've had a lot of people ask me, well, what if the 60 days are up and we request the money and the listing broker on day 20 is about to release it, but then the seller files for mediation? Do they still have to send it? Well, according to this, they should, right? Because it says prior to the receipt of buyer's request for distribution. Now, that doesn't mean that the seller can't take the buyer to the district justice or mediation. It can still mediate. It's just the deposit money is now back in the hands of the buyer. Okay. Any questions on that, or any discussion, or any different opinion of that? Okay. Go to part B here. (26D), buyer and seller agree that a broker who holds or distributes deposit monies pursuant to the terms of paragraph 26 or PA law will not be liable. Buyer and seller agree that if any broker or affiliated licensee is named in litigation regarding deposit monies, the attorney fees and costs of the brokers and licensees will be paid by the party naming them in the litigation. Okay, so they'll pay our attorney fee if we're mentioned. E, seller has the option of retaining all sums paid by buyer, including the deposit monies, should buyer, 1, fail to make any additional payments as specified in paragraph 2, and I wrote down in there additional deposit, or 2, furnish false or incomplete information to seller, broker, or any other party identified in this agreement concerning buyer's legal or financial status, or 3, violate or fail to fulfill and perform any other terms or conditions of this agreement. So throughout the contract, and Brooks and I mentioned this when I had mentioned that this is back in like week 2, that throughout this contract, it mentions the buyer getting the deposit back if this doesn't happen or if that happens. But it doesn't clearly state each time where the seller can keep the deposit money. It's only here at 26E, okay? But it's pretty in-depth as to how the seller can redeem the deposit money. And if a buyer agent claims deposit money and you as a list agent feels that they shouldn't get it back, then you need to cite here 26E why you feel the seller should have the deposit money, and then prove it. Okay. Any other questions on 26E? Okay. When I read this, actually number 1 was the first one that caught my eye. Fail to make any additional payments as specified in paragraph 2, meaning additional deposits. You know, it's just common sense if they don't fulfill the contract, but it's written clearly there in case, you know, you decide to make an offer with $5,000 deposit, and then after a satisfactory home inspection, you're going to give them another $10,000, and they don't do that. Then according to this, the seller would be entitled to that initial deposit money. Okay. F, 26F, unless otherwise checked in paragraph 26G, seller may elect to retain those sums paid by buyer, including deposit monies, 1, on account of purchase price, 2, as monies to be applied to seller's damages, or 3, as liquidated damages for such default. 26G, the checkbox here. Seller is limited to retaining sums paid by buyer, including deposit monies as liquidated damages. So when do you check mark that box? Anybody? As a buyer agent.
Always.
Okay. And what that states is the most the seller can collect from you is the sums paid by the buyers, including deposit monies. Okay. Now, let's say, and this came up recently too, a buyer did FHA repairs at a house. Okay. They made the repairs at a house. And then for whatever reason, they quit their job. And they didn't tell anybody about it, okay? So when the lender called to verify employment, they no longer worked there. So they had a $1,000 deposit, and then they made about $750 in FHA repairs, okay? Now, the buyer did say that they were in default, they were okay with it. According to this, does the seller have to pay them back for the $750 in repairs?
No.
Right. They just can't collect more than that. They're limited to retain the sums paid by buyer. Okay. Does everybody understand that? Okay. 26H. If seller retains all sums paid by buyer, including deposit monies, as liquidated damages pursuant to paragraph 26F or G, buyer and seller are released from further liability or obligation, and this agreement is void. 26I. Brokers and licensees are not responsible for unpaid deposits. Okay. So if somebody doesn't give us a deposit when they said they would, we're not responsible for that. If you want to go after the buyer, go ahead, but just put the house back on the market. Okay. Number 27, mediation. Years ago, when we did a lot of reload deals, relocation companies would always have us strike this out. Okay. But 27 states, buyer and seller will submit all disputes or claims that arise from this agreement, including disputes and claims over deposit monies, to mediation. Mediation will be conducted in accordance with the rules and procedures of the home buyer's dispute resolution system, unless it is not available, in which case buyer and seller will mediate according to the terms of the mediation system offered or endorsed by the local association of realtors. Mediation fees contained in the mediator's fee schedule will be divided equally among the parties and will be paid before the mediation conference. Okay, right there it states, split. Legal proceedings may be initiated prior to the completion of the mediation process to stop any statute of limitations from expiring and for the purpose of indexing a lis pendens by buyer to present the transfer of title to a third party when buyer is seeking to purchase the property. The parties agree that all proceedings shall be stayed until the completion of mediation, that a court of competent jurisdiction may award attorney's fees to the prevailing party should the court find that a party has unreasonably breached this provision or acted in bad faith. Any agreement reached through mediation and signed by the parties will be binding. Okay, that's important because if there is no agreement, mediation isn't binding the judgment. Okay, but if it's signed and agreed upon, then it is binding. Any agreement to mediate disputes or claims arising from this agreement will survive settlement. So one phrase in there, a lis pendens, what is that? Definition of lis pendens. In United States law, lis pendens, Latin for suit pending, is a written notice that a lawsuit has been filed concerning real estate involving either the title to the property or a claimed ownership interest in it. The notice is usually filed in the county land records office. Recording a lis pendens against a piece of property alerts a potential purchaser or lender that the property's title is in question, which makes the property less attractive to a buyer or lender. Once the notice is filed, the legal title of anyone who purchases the land or property described in the notice is subject to the outcome of the lawsuit. So a seller backs out of the sale for no reason. A buyer could put a lis pendens on the property. Okay. And according to this, then they are claiming that they have an ownership in the property. And if that current seller tries to go sell it, they can't get clear title. Okay. Does that happen to any of you where the seller backed out for no reason? We've had that happen years ago. And I remember Tim was the list agent in that case. And the seller backed out. And according to the listing contract, we bought them a bona fide buyer because they had accepted the deal and signed a contract, an agreement of sale, and we were able to get our commission out of it. And at that time, that was during the Obama administration when they were giving the $9,000 first-time home buyer credit. Well, when the property went under contract, the buyer was within that time frame to get that $9,000. When the seller backed out, and the buyer had to go look for another house, that deal was off the table. The government took that deal off. There was no more $9,000. So not only did we get our deposit money or commission money, but we also got the buyer the $9,000. So it costed this seller almost $24,000 to stay in their house. Okay.
That happened to me, Kong. I had a seller back out like 5 days before closing.
Yeah.
And they had to pay all of the commissions, and then they had to pay my person's like escrow back, their title search, their inspection money, everything. I think it cost them $24,000 as well, right in there, to get out of it completely.
Right.
And then you know what's hilarious? Like a week later, they contacted me through Messenger. I was representing the buyer. They had an agent representing them. They messaged me on Facebook and asked if I would list their house for sale. I was like, no.
Yeah, if you put up a non-refundable deposit, right? As a seller. All right, 28, the release. Buyer releases quick claims and forever discharges seller, all brokers, their licensees, employees, and any officer or partner or any one of them and any other person, firm, or corporation, that could be title company, okay, who may be liable by or through them from any and all claims, losses, or demands, including but not limited to personal injury and property damage and all of the consequences thereof, whether known or not, which may arise from the presence of termites or other wood-boring insects, radon, lead-based paint hazards, mold, fungi, or indoor air quality, environmental hazards, any defects in the individual on-lot sewage disposal system or deficiencies in the on-site water service system, or any defects or conditions on the property. Should seller be in default under the terms of this agreement or in violation of any seller disclosure law or regulation, this release does not deprive buyer of any right to pursue any remedies that may be available under law or equity. This release will survive settlement. Okay. Now, 29, the Real Estate Recovery Fund. I don't think I've ever heard of a story where money was collected through this fund, but 29 states that a real estate recovery fund exists to reimburse any persons who have obtained a final civil judgment. Okay, you've gone through the whole court system against a PA real estate licensee or licensee's affiliates owing to fraud, misrepresentation, or deceit in a real estate transaction. And so they also have to do the second part, and who have been unable to collect the judgment after exhausting all legal and equitable remedies. For complete details about the fund, call this number. So I also wrote down in there that this recovery fund is also mentioned in the consumer notice when buyer and seller first meet with you and sign up. Okay. But the key there is you don't just call them up and ask for money. You have to have a final civil judgment in your favor. And you also have to exhaust every method to try to get payment from the licensee. Okay. 30, communications with buyer and or seller. A, if buyer is obtaining mortgage financing, buyer shall promptly deliver to broker for buyer, if any, a copy of all loan estimates and closing disclosures upon receipt. Okay. B, wherever this agreement contains a provision that requires or allows communication delivery to a buyer, that provision shall be satisfied by communication delivery to the broker for the buyer, if any, except for documents required to be delivered pursuant to paragraph 16, and that is the condo docs, HOA docs. Okay. If there is no broker for buyer, those provisions may be satisfied only by communication delivery being made directly to the buyer unless otherwise agreed to by the parties. Wherever this agreement contains a provision that requires or allows communication delivery to a seller, that provision shall be satisfied by communication delivery to the broker for seller, if any. If there is no broker for seller, no seller rep, those provisions may be satisfied only by communication delivery being made directly to the seller unless otherwise agreed to by the parties. So basically it's saying talk to the buyer rep, talk to the seller rep, except for documents required to be delivered pursuant to paragraph 16, which is the HOA condo docs. I didn't know that that was in there. So sometimes I think you need the buyer's info to fill out the condo questionnaire, right? The documents to get the resale cert. So there you go. 31, headings. The section and paragraph headings in this agreement are for the convenience only and are not intended to indicate all of the matter in the sections which follow them. They shall have no effect whatsoever in determining the rights, obligations, or intent of the parties. So all these paragraphs and headings, you know, the first 30, they're just there for convenience. Okay. 32, special clauses. A, the following are attached to and made part of this agreement if checked. So the 6 that they have there are the common ones, right? Or at least used to be the common ones. That's where I would check mark escalation clause, any addendums to the agreement of sale, just put it there. Now, if you don't, let's say you have an escalation clause and you don't check mark that, okay? Then if you go to use the escalation clause, it's technically not part of the contract, right? If an agent sends you that, correct? It also, let's say you do use the escalation clause and you send this deal to the bank, you didn't make any changes. All you did was on the escalation clause at the bottom there, changed the price from 300 to 350. And the appraiser gets it and nobody talks to the appraiser. You just give him the combo, he goes through it. And he gets the contract with no escalation clause, and there's no indication that there is an escalation clause because it's not checkmarked on this last page. He's probably going to base his appraisal off of a purchase price of 300K, right? So just be careful of that. If you have an escalation clause, checkmark that, or an appraisal contingency, checkmark that.
Can I say something?
Yeah.
I'm
Karen.
going through that right now, except I did add the escalation clause in there.
Yeah.
So it's really bad situation. Not really terrible, but so just make sure you mention it to the lender just in case that there is an escalation addendum,
Right.
because yeah, it makes a difference.
Now, Regina and I had a conversation the other night about the escalation clause. We got an offer in that was cash. So we just changed the price on the escalation clause to whatever the new price is and let it go because it's cash, no appraisal. However, we were saying if this wasn't cash and it was finance, according to the escalation clause, you can actually go back and change the price on the contract and everybody has to initial it. It states it in the escalation clause, and it's probably a good idea if it is finance to go back and change that price. Yep.
Yeah, no, that is a good idea, actually.
Yeah. Okay.
I think we did that. I'm not sure that we did it with that one, but there was another one that we did that with, that we actually went back, changed the price and had everybody initial. But yeah.
Awesome.
Lessons learned.
You learn, right? Part B, additional terms, and I wrote in there, leave blank. Find the right form, section of contract, or consult with an attorney if you feel like you're going to have to write something in. Okay. So what do we always see in that section? Most common by agents, home must appraise. Okay. And I wrote in there, use the appraisal contingency. Or there probably is already one if you filled out the mortgage contingency properly. Okay. Sellers indicate certifies blank is blank. Years ago, there was a real estate company in our area that wrote 2 statements, and every time I get an offer from them, I would just cross it off and leave it at that. But the one thing they always wrote is seller verifies that the home is 0.2 acres. Seller verifies that the taxes are this much. Okay. And my argument with them was, well, yeah, the taxes are that much face value, but what if your people like to pay late? What if your people like to pay early and get the 2% discount? Then it's not that amount, it's a different amount. Okay. Seller to provide blank in 10 days. For example, seller has to provide a perk and probe in 10 days. Well, if you're going to do that, then you might as well just have a septic inspection. You know, because then all the terms are written in there, the who, what, where, when, and how. So what if they don't provide it in 10 days? What happens? Doesn't direct you anywhere by writing that. Okay. Buyer will allow seller to stay in home for up to 30 days after settlement. That's a terrible phrase to write on that last page, because what are the legalities behind that? Are they allowed to have a dog? What about insurance? What if the house burns down while they were there? You know, at least the PAR form, the post-settlement one, gives you some legal terms in there. You know, when do they have to vacate? What if they don't vacate? What is security deposit? So again, I always like to leave that section blank. for that reason, because there is a form or some section in the contract that already covers that. Okay. Line 795, buyer and seller acknowledges receipt of a copy of this agreement at the time of signing. This agreement may be executed in one or more counterparts, each of which shall be deemed to be an original, and which counterparts together shall constitute one and the same agreement of the parties. So you send this agreement of sale to the sellers, okay? And the list agent says, well, these folks are divorced. You know, one lives in California, one lives in New York, okay? And they both, I know it's a stretch because you can just DocuSign it and send it to both, but they both want their attorneys to look at it, and they printed it off, and one signs it, you know, with wet ink, and the other signs it with wet ink. And now you have two copies, but they're the same contract. That's stating that if that's done, it still constitutes one executed contract. Okay. Both parties don't have to sign on the same contract. As long as they sign the same contract, then it's still executed. Okay. Notice to parties when signing this agreement, notice to parties when signed, this agreement is a binding contract. Parties to this transaction are advised to consult a PA real estate attorney before signing if they desire legal advice. Return of this agreement and any addenda and amendments, including return by electronic transmission bearing the signatures of all parties, constitutes acceptance by the parties. So there you go. We're just talking about DocuSign there, electronic signatures. This allows it. Now, 802 to 806, 4 things the buyer has to initial on. 1, buyer has received a consumer notice. 2, buyer has received a statement of buyer's estimated closing costs. 3, buyer has received a deposit money notice for cooperative sales when broker for seller is holding deposit money before signing this agreement. So you definitely have to have the buyer initial the first 2. Okay. They initial the third one if it's a co-broke deal. Okay. If it's a broker, dual agency for broker, you don't need to sign that. And then the last one is if the house was built before 1978 for lead-based paint. Then the buyer signs there. And then line 811 and 812, we have a little notice for the seller. Seller has received a consumer notice as adopted by the State Real Estate Commission. And seller has received a statement of seller's estimated closing costs before signing this agreement. And then the seller signs there. So, any questions? Any comments?
Tom,
Yes.
it's Sue. Going back to, let me find it here. Going back to page 13,
Okay.
26G. I see
Yes.
on your notes, if the deposit is low, do not allow checkbox in 26G.
Yes. Okay. So let's say the house is $250,000. Okay. And you get a deposit for $2,000. That's not a lot, right? Can we all agree on a $250,000 house?
Mhm.
Okay. And let's say the buyer can't give any more than 2,000 right now because you know they just don't have it right now. They're getting money out of stocks or whatnot, or selling something, or selling their house to buy this house. Okay. So if that box is checkmarked, and if the buyer defaults on this contract, the most your seller can collect is $2,000. Okay, but because the deposit is low and you accepted a low deposit as a seller and list agent, you should go back to the buyer and says, we'll accept $2,000, but we want to have that box unchecked, because if this deal goes south, then the seller should be able to collect more than $2,000 and take your client to court for moving expenses. You know, we're moving out of the house for you. We're taking the house off the market in a prime real estate market. So it's like a seesaw action. The higher the deposit, yes, be comfortable with check marking that box. The lower deposit, that box should be unchecked.
And that's kind of just a discretionary thing. I mean, what are most
Yes.
people getting for deposits? 10%?
Well, the norm, I wouldn't say the norm, but it used to be like right around 1%, right? Give or take.
Mhm.
You know, I just had one where the house was 290,000 and the deposit was 100,000. So yes, it's very discretionary, and it's really, again, up to the seller what they feel comfortable with. And you can say to them, hey, if this deal falls through, are you okay with this deposit amount, collecting that much? Because what do you think, Sue?
I mean,
Probably what,
that makes
99%
sense.
of the contracts have that checked, right? Irregardless
It
of.
does make
deposit amount.
sense, and we have gone back several times with contracts and asked for more of a deposit.
Right.
And quite honestly, in this market, pretty much everybody is able and willing to.
Yeah. Yeah.
We have had a couple instances though, where it was a case where they were willing to pay the difference between the purchase price and any appraisal cut.
Mm-hmm.
And that was their excuse for a lower deposit, because they wanted to keep money in reserve should they need to do that.
Well, it doesn't really matter, because they're going to have to fork that money over at settlement anyways.
Exactly. Exactly. But that's what their thinking was.
Right. You might as well just
Hong,
put it all out there then. Yeah, Morgan.
what are you guys seeing for deposits up there? Because I feel like down here, we're not seeing that kind of stuff. It's more like $1,000 still.
No, we're seeing you know, 5, 10, 15, you know, at least 2% anymore. So on a $300,000 house, we're seeing like 5, 7, 10 grand. At least.
We got 100,000 the other day.
Yeah, that's what I was just saying. We got 100 grand on 290. I mean, that's 37%. So, any other questions throughout this whole contract, or we have all these videos, and
I do have one more.
yeah, go ahead, Sue.
With the, and it's not about what we just went over, but with interest rates climbing, what do you think is a good, comfortable spread for people to put in that box for, you know, the interest rates?
Oh yeah, I just went through that this weekend for the first time ever, and the list agent wanted me to put in 6.5%, a spread from 5 to 6.5, because my client, they were not locked in yet, obviously, and he wanted to see a good spread. I would consult with a lender right now and just see, you know, where they feel comfortable with this, with your buyer, because actually I was going to put in that 6.5, but then when I talked to the lender goes, no, you can't do that, because at that purchase price and that money down, the max I can get them approved is at 6.25.
Oh, that's right.
Yeah,
That's
so
right.
that 0.25%, they wouldn't be able to get the house if the rates went up that high.
Okay.
Con, I have a question on in the same box.
Yeah,
What do you do when it's a co-broke? You have it's your listing. And the co-broke puts in for the lender TBD.
Now, they had a pre-approval with the contract, but they still put in lender to be determined.
right. And somebody else can chime in. Here's my opinion of it. I'm kind of okay with that. Okay. And I guess it sometimes depends on the experience of the agent as well. But I'm kind of okay with to be determined, because in the contract, it does state in the contract that the buyer will get a loan per the mortgage contingency, whoever you wrote in there, or a reputable lender within X amount of days. So you're still following the same guidelines. You know, you have to get a mortgage application in 7 days. You have to do this, you have to do that. It's just if they put to be determined, you know, they still have to go through that process, right?
Right.
But I can tell you, it makes the seller nervous when you're doing competing offers,
It does,
them not knowing who that lender may be.
right? Absolutely.
And it does kind of tie the hands of us presenting that offer, because we like the option to be able to call the lender, which you can do, and talk to them.
Right.
So you kind of lost that control a little bit.
I know. Yeah, in a competing situation, probably not a good idea to put to be determined. But in any other situation, if you were the only offer and the buyer is still undecided, remember, they still have to have mortgage application within X amount of days, 7 if not written.
Thank you.
Yep. Speaking of mortgages, one thing that happened over the weekend, I went on a listing appointment with one of our agents in the office, and we talked to a seller. It was an expired listing in Lancaster, and the gentleman had a VA loan, 2 years old. He just bought this thing 2 years ago, 2020. And I looked at his mortgage paperwork that he provided to me when he had his deal, you know, this title binder, his title folder. And he had a rate of 2.75 on this thing. And it occurred to me, well, somebody could take over this loan. It could be assumable, especially now where the rates are at 5%. That could be very enticing to somebody to get a VA loan at 5 or at 2.75. The only thing is, the house is now listed at 370. The loan amount is at 325. So the next buyer would have to cover that, what is that, $45,000 difference plus closing costs. So by my calculations, they needed $60,000 to assume that loan. But we called the lender that initiated that loan, and he said, yeah, it can be done. So just something to think about when you're going to these properties that have a government-backed loan, FHA, VA, especially if they bought within the last, you know, few years, their loan could be assumable, and that could be enticing.
Con, then the seller is no longer allowed to use a VA loan in the future.
I don't know about that.
That's what I've always been told.
Okay.
He cannot use his VA, so you have to talk about the pros and cons. On the seller side, if he was to buy again and want to use his VA, he's not eligible.
Okay.
You can't have multiple VAs out there, and it stays, I believe it stays, maybe
It
that
stays with the seller?
It stays
Okay.
under the seller's name, and he won't be able to use it again. And I don't know if there's any side effects if they ever
Yeah.
default or don't make any mortgage payments on that either. So I think there should be some further
Well, no,
investigation.
the next buyer would have to qualify to, they have to be a VA. They can't just assume it. They have to be VA as well, and then it goes into their name.
All right, what? I don't know that for
Yeah,
sure.
we'll
I
have to
just-
clarify that. We'll get back
Yeah.
on Tuesday with that, but
I didn't
yeah.
think they had to be VA, but it could be assumable, but then I was always told the seller would not be able to use VA until
Right.
that was either out of the other people's names or, you know, resold or something, but I don't know. It's just a question that I had.
Okay, we'll check on that, but according to this lender, you know, the buyer had to qualify, they had to be VA, and the loan would be, they had to go through the whole qualifying process and everything, and then they can then take over the loan under their name. So,
Thank you,
All
sorry.
yep, no, good comment. We'll check on that, all right? Anybody else? Okay. We'll stop it here, and we'll figure something else to go over on Thursdays, and send you a list of forms or whatever. If there's a form that you want us to go over, let us know, email me, and we'll make sure that we address it and get everybody to be on the same page about it. Okay?
Thanks, Tom.
Yep, have a great week, all right?